Today we'll be looking at the people of the state of New York versus Robert Versaggi. Around 1986, the Eastman Kodak Corporation, headquartered in Rochester, New York, utilized a landline telephone system controlled by two SL-100 computers. One computer located at Kodak's State Street office controlled 7,000 telephone lines. The second computer located at Kodak Park Complex controlled 21,000 telephone lines. On November 10, 1986, approximately 2,560 lines at the Kodak Park Complex were shut down, and 1,920 were impaired for an hour and a half before they were restored, thereby causing a substantial interruption in telephone service, including the restriction of access to 911 in case of an emergency.
How about global thermonuclear war?
Wouldn't you prefer a good game of chess?
On November 19, 1986, a second interruption occurred. All service to the State Street office was shut down for 4 minutes, paralyzing Kodak's ability to conduct its domestic and international business, in addition to preventing calls to emergency services if the need had arisen. Kodak employee Robert Versaggi was responsible for maintaining and repairing several phone systems within the Kodak network, but did not work on the SL-100 computers. Versaggi was able to work from home and was assigned special equipment which allowed him to remotely access the Kodak phone systems. Once investigators began examining phone records, they then realized that Versaggi had accessed the SL-100 systems on both dates. Versaggi was then subsequently arrested and charged with 2 counts of computer tampering in the second degree. Before we look at the legal issues surrounding the Versaggi case, we have to look at the statutes that govern what Versaggi has been charged with. And specifically, those statutes deal with New York Penal Law Section 156, specifically with offenses involving computers. And before we actually look at the statute, we have to take a look at some definitions and understand the meaning of them. Computer means a device or group of devices which, by manipulation of electronic, magnetic, optical, or electrochemical impulses pursuant to a computer program, can automatically perform arithmetic, logical, storage, or retrieval operations with or on computer data, and includes any connected or directly related device, equipment, or facility which enables such computer to store, retrieve, or communicate to or from a person, another computer, or another device the results of computer operations, computer programs, or computer data. Computer program is property and means an ordered set of data representing coded instructions or statements that, when executed by a computer, cause the computer to process data or direct the computer to perform one or more computer operations or both, and may be in any form, including magnetic storage media, punch cards, or stored internally in the memory of the computer. Computer data is property and means a representation of information, knowledge, facts, concepts, or instructions which are being processed or have been processed in a computer and may be in any form, including magnetic storage media, punch cards, or stored internally in the memory of the computer. Computer service means any and all services provided by or through the facilities of any computer communication system allowing the input, output, examination, or transfer of computer data or computer programs from one computer to another. Computer material is property and means any computer data or computer program which a. contains records of the medical history or medical treatment of an identified or readily identifiable individual or individuals. This term shall not apply to the gaining access to or duplication solely of the medical history or medical treatment records of a person by that person or by another specifically authorized by the person whose records are gained access to or duplicated, or b. contains records maintained by the state or any political subdivision thereof, or any governmental instrumentality within the state which contains any information concerning a person as defined in subdivision 7 of section 10 of this chapter, which because of name, number, symbol, mark, or other identifier can be used to identify the person, and which is otherwise prohibited by law from being disclosed. This term shall not apply to the gaining access to or duplication solely of records of a person by that person or by another specifically authorized by the person whose records are gained access to or duplicated. Or C, is not and is not intended to be available to anyone other than the person or persons rightfully in possession thereof, or selected persons having access thereto with his, her, or their consent, and which accords or may accord such rightful possessors an advantage over competitors or other persons who do not have knowledge or the benefit thereof. Computer network means the interconnection of hardwire or wireless communication lines with a computer through remote terminals, or a complex consisting of two or more interconnected computers. Access means to instruct, communicate with, store data in, retrieve from, or otherwise make use of any resources of a computer, physically, directly, or by electronic means. Without authorization means to use or to access a computer, computer service, or computer network without the permission of the owner or lessor, or someone licensed or privileged by the owner or lessor, where such person knew that his or her use or access was without permission, after actual notice to such person that use or access was without permission. It shall also mean the access of a computer service by a person without permission, where such person knew that such access was without permission, or after actual notice to such person that such access was without permission. Proof that such person used or accessed a computer, computer service, or computer network through the knowing use of a set of instructions, code, or computer program that bypasses, defrauds, or otherwise circumvents a security measure installed or used with the user's authorization on the computer, computer service, or computer network shall be presumptive evidence that such a person used or accessed such computer, computer service, or computer network without authorization. Now that we've looked at definitions under New York Penal Law Section 156, let's take a look at the statute, specifically what Versaggi was charged with. The statute itself is 156.20, which is entitled Computer Tampering in the Fourth Degree. Just as a side note, in 1993 the statute was changed from a second-degree crime to a fourth-degree crime. The statute reads, a person is guilty of computer tampering in the fourth degree when he or she uses, causes to be used, or accesses a computer, computer service, or computer network without authorization, and he or she intentionally alters in any manner or destroys computer data or a computer program of another person. Computer tampering in the fourth degree is a Class A misdemeanor. Now that we've got the statutes down and the definitions of the elements within the statutes, let's talk about the history of Versaggi's case in the court system. The defendant, Versaggi, was convicted in Rochester Municipal Court of 2 counts of computer tampering in the second degree. The defendant then appealed the municipal court decision to the Monroe County Court, which affirmed the lower court's decision. The defendant was then granted permission for an appeal to the Court of Appeals of New York, which brings us to the appeals court decision that we're going to review next. Let's first look at the facts of the case in Versaggi. In appeal, the defendant renewed the argument that he cannot be guilty of tampering because he merely entered commands which allowed the disconnect instructions of each program to function. The defendant maintained that he did not alter the programs, he used what was available to shut them down. Kodak technicians provided evidence that during the first incident of disruption, a user had accessed the defendant's electronic mail and then accessed one of the SL-100 computers and issued commands that caused the computer to shut down. This slide brings us to the opinion of the New York Court of Appeals. In making their decision, the Court of Appeals opined that the defendant, by disconnecting the application programs and commanding the computers to shut down, he altered the programs in some manner. They further stated that whether the defendant used existing instructions to direct the phone systems offline or input new instructions accomplishing the same thing is legally irrelevant. The court further opined that the defendant's conduct constituted tampering within the intent of the statute because it altered the computer programs at Kodak's State Street office and Kodak Park complex by interrupting the phone service at those two facilities. Based on the interpretation of the facts surrounding this case by the New York Court of Appeals, the court steadfastly affirmed the county court's decision. Okay, let's recap what we went over. New York Penal Law Section 156.20 clearly states a person is guilty of computer tampering in the fourth degree when he or she uses, causes to be used, or accesses a computer, computer device, or a computer network without authorization, and he or she intentionally alters in any manner or destroys computer data or a computer program of another person. In this case, Versaggi was found guilty of tampering with the SL100 computers. Okay, and we discussed before that this is now a fourth degree offense versus the second degree that Versaggi committed during that time. Accesses a computer network without authorization. He regularly did not work on the SL100 computers, so he was not normally authorized to access those. And he intentionally altered the computer program that controls the phone systems within Kodak's facilities and actually shut them down for a period. Therefore, the court, as you saw several times, affirmed each other's opinions that in fact that Versaggi was guilty of committing that offense.